All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for the Child Welfare 2025 Legislative Update. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. The training is being recorded. If you're registered, you're going to receive a copy of the recording from Zoom via email within 24 hours. If you don't see that email, no worries. We're also going to be posting it on YouTube and on the Florida Children's First website as well. In the description of the YouTube video, you're also going to find information such as the CLE code and a link to the materials. The training was approved by the Florida Bar for 1.5 General CLE and 1.5 Juvenile Law Certification Credits. I will announce the CLE code towards the end of the session. That code will also be included in the email. It would also be included into the YouTube description. And if any of you need a certificate of attendance, you can email me after the webinar is done so I can prepare one for you. I will include those instructions as well in the email. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility, you can let me know. Now, questions and answers. If you have any questions during the webinar, feel free to use either the Q&A feature or use the chat as well. We'll do our best to address these questions as they come in. We have more than enough time, so we'll try to make sure we read them out loud for the benefit of the audience as well. So, and instead of introducing each speaker, I'm just gonna pass it on to our speakers because they're gonna do a quick self-intro. So without further ado, please welcome our friends from Florida Children's First. We have Robin, we have Geori, and we have Janine. So Robin, Geori, and Janine, the floor is yours.
Thank you very much. Good afternoon, everyone. Good to see your names in the participant list, and we are looking forward to working through this legislative update with you. So this is the first time ever we've done a legislative update while the legislature is technically still in session. It is very bizarre. It's my understanding that they are reconvening this evening at 7 p.m. to presumably to vote on the budget and to close out the session. But there are many of the bills that have an effective date of July 1st. So we went ahead and scheduled this legislative update. You will see as we go through some of the bills that not all of them have been presented to or signed by the governor yet. So we will make note of that. It is possible until they are signed, or they can also go into effect without the governor's signature. It is possible that some of the bills we talk about will not go into effect. So we'll bring that to your attention as we go along. For those who haven't been to one of our legislative updates before, my name is Robin Rosenberg. I'm the Deputy Director of Florida's Children First. We are a statewide advocacy organization focused on the rights of children that are served by the state. Florida's Children First is closely aligned with a youth affiliate called Florida Youth Shine. And our executive director, Geori Seldine, will tell you more about that when their bill is up on our agenda. So at Florida's Children First, we have been in existence for over 20 years, focusing on the rights of children and foster care, trying to make sure that the laws and the policies and how they are implemented support what children want and what they need and what they ask for from the perspective of the child and their rights. So we are very pleased to be part of the Legal Services Network. We work closely with our colleagues at legal aid programs around the state and now with colleagues around the country on national policy and issues of common interest to advocates for children in the child welfare system. One of the key things that we do that we offer is the Florida Dependency Law Center. So some of you may have gotten information about this training from an email that I sent to the Florida Dependency Law Center users. If you are an attorney or a judge and you are not already a registered user on this website, I strongly encourage you to do that. It's floridadependencylaw.org. Registration is free. There's no charge for using the website, but it is limited to lawyers in good standing with the Florida Bar. We share a lot of information with the listserv, the registered users, and there are many resources and communication tools that will help you in your practice of law in child welfare and other juvenile related systems. So if you're not already a Florida Dependency Law Center user, I strongly encourage you to do that. So today, what are we talking about? What passed and what failed. And this was a very interesting session. Compared to years past, far fewer bills, really made much progress. So our what passed list is shorter than normal, but these are the key bills that we're going to talk about today. And I'm going to start with the I had written this originally as the Big Beautiful Child Welfare Bill. I'm just going to call it the Child Welfare Bill. That's the title of it. Senate Bill 7012. And you will see that I've put the icon of the train underneath it because this bill became essentially the Child Welfare Train Bill. So for those that aren't familiar in the legislature, how the legislature works, sometimes when there's a bill that appears to be moving forward, everyone who has related issues will try to add their bills onto the train. And so this became, sometimes there are a couple trains. Last year there were some big bills that were trains. This year is just this one bill that became the train. So let's talk about this bill. So you will see by my yellow highlight that this bill is intended to go into effect on July 1st. It has not yet been presented to the governor. So that's what the yellow highlight indicates. So there are a bunch of different things that are in this bill. Um, it started with the safe harbor placements and looking at commercial sexual exploitation of children. So DCF is already required to prepare reports to the legislature about the prevalence of child commercial sexual exploitation, which they switched the words around and now it's commercial sexual exploitation of children. Um, DCF is supposed to do these screening tools with children at various points in time when they are coming into care or have been in care and make reports to the legislature. OPAGA is the Office of, I'm not even going to say it. It's like our general accounting office in Florida. They do studies for the legislature. They've been having difficulty preparing their reports because DCF has been collecting this information on paper tools and assessments. So while DCF and under this bill, DCF will be required to keep those paper tools, but it also has to make the data available so that it can be extracted, analyzed, and aggregated. So the legislature wants better reporting, and OPAGA for several years has said collecting this data is difficult, and we're having a hard time giving you an accurate report on how many kids have been trafficked and what their needs are. So this first part is to get to collect better data. It also has in the bill not a section of statute, but a direction to DCF to do a study on the bed capacity and a gap analysis for CSEC, those are sexually exploited children. This study has to be done by December 31st of this year. And it is, so DCF is to contract with an outside entity to look at what's the current capacity and the current demand and projected future demand for different types of placements. And so they're to collect this data by DCF region. And the three types of placements they're looking at are the residential treatment beds, therapeutic foster home placements that are specifically for victims of trafficking, as well as non-residential treatment services. So the legislature is trying to do right by kids and who are trafficked. They want better data. So those two components are kind of bookends of the bill if you were to look at SB 7012 itself. The next section of the bill deals with domestic violence shelters. And you can see I put in the upper right corner our little train again. This was bill language from a separate bill. And once 7012 was the one going forward, this domestic violence language was added into Senate Bill 7012. DCF certifies Florida's domestic violence shelters, and there is a requirement in statute that there's a demonstration of need before a new domestic violence shelter can be opened. Apparently, there were some hiccups in how that was occurring, and maybe unnecessary delays when there are parts of the state that needed a new domestic violence shelter. So, this revision allows DCF to issue provisional certificates, um, and to waive the performance requirements, because one of the requirements is that you demonstrate a history of as a nonprofit providing services if there is an area with an identified domestic violence need for domestic violence shelter. The next piece of this is also, you can see a train. It came from another bill and was added in. And this has to do with the um, licensure of childcare facilities. So, childcare facilities are daycares, and the licensure of foster homes and child caring and placing agencies. Those are the ones that we're concerned with in the child welfare system. So, that is the placing agencies and the licensing agencies for foster homes and for group homes. So, if you're familiar, people who work in with people who are vulnerable in state agencies are required to do a level 2 background screen, and that will determine if there's a prior conviction that disqualifies the person from working with that vulnerable population. Under the current law, an applicant can seek an exemption from disqualification and receive it, and it can then go to work with any vulnerable population. So, and we've clicked, and you will be getting a PDF of the slides after when you get the video, the link to the video. So we will be sending you the slides. So, exemption for disqualification is a process. Florida's Children First has put together a packet of information to help people understand if they are being precluded from work because of a prior conviction. But the current system for exempting people from disqualification, in other words, permitting them to do work, is a one size fits all. And so this revision allows DCF to make a specific exemption. So it may be appropriate, for example, to exempt somebody who has drug convictions to work with a population of people who are current drug users. It may be appropriate to give an exemption to work with the elderly, but not to work with children. So the purpose of the change in this is to take away the one size fits all blanket exemption and allow DCF to tailor the exemption to the situation. And I'm looking at my questions, not seeing any yet. So I'm going to keep going along. And you'll see, I put the little gavel at the bottom to tell you there's a practice tip. And if you want more information on exemptions, you can click on that link. Okay. There is a desire to expand the workforce. So this change to the bill, change to existing law 402.402, is intended to increase and expand the population of essentially frontline workers and attorneys and CPIs. So it is creating, if there is funding for it, subject to appropriation, a new recruitment program. And the intended target is to go after people that already have public safety and public service. So former police, military, first responders, etc. They are the target. The state has already been targeting the police and military first responders for CPI recruitment, and this is sort of expanding that and creating more of a formal program and presumably funding a program to reach out and to try to identify and recruit and train more folks to work in the system. So I think everybody who's been involved in the system knows that turnover is really detrimental to kids and families. So if they can expand the workforce, keep reasonable caseloads, and recruit and retain, then everybody's going to be better off in the system. So that's the purpose of that section of the the new law. Um, Again, you see this next piece is also part of a train, meaning it came from another bill. Two sections that relate to the community-based care lead agencies. And I'm sure these sections are really important for those lead agencies and how they proceed. It just seems like it would be pretty common sense that a subcontractor should not be liable for for the actions of the entity that hired them, but they're going to make it clear in statute. And it also removes the requirement of posting bond for the CBCs. So, day to day, how does that affect kids? Maybe not. Is it really important to CBCs? I'm sure it is. This next section, I am very excited about. I put a little heart next to it, and that is the inclusion or creation of a pilot program for treatment foster care. So, treatment foster care is um, shown to be a clinically effective and cost effective alternative to residential treatment facilities. This is targeted for kids who have behavioral and emotional disorders that would otherwise end up possibly in a SIP or in a therapeutic foster home, or because we don't have enough of either of those, bouncing around through the system in inappropriate placements. And so rather than institutionalizing children, the purpose of treatment foster care is to recruit and train and support caregivers so that children can have their behavioral and mental health needs addressed in a home, not in an institution. So this is a 4-year pilot project. 2 judicial circuits will be identified based on the greatest need. Um, DCF will be creating a process for placement and for payment of caregivers and establishing the program standards. There has to be also, they'll have to obtain an evaluation. So there are already evidence-based programs. Oregon Treatment Foster Care is one. Together Facing the Challenge is another, but DCF does not have to select one of those existing programs. It can create its own version of treatment foster care, or select a different version. But the concept of treating children in their homes using this project is it's a great concept. I'm very excited about the possibility of it. So who would be eligible for treatment foster care? Well, the law says children who have high resource indicators. So frequent placement changes and DJJ involvement are sort of the two touchstones that would give rise to the concept that this might be a child eligible for treatment foster care. These children have to be dependent. So this is not children in the community. They have to be in the dependency system. And treatment foster care can also be considered as the continuation of a placement when a child is coming out of an inpatient residential. So treatment foster care can be a step down from inpatient residential. Um, these are the standards for the pilot project, the minimum standards that are set out by the legislation. So I've got my thumbs down and boo, because on the part that talks about the time limitation. So it's expensive. It's not an inexpensive option. Um, and it is intended to provide therapeutic services, which will hopefully be effective. So the plan is for kids to stay in treatment foster care for 9 months. There's a possibility of a 3-month extension. What I say boo and thumbs down about is because this is another institutionalized trauma or transition. So anytime we put a kid in a home and they do well, and then we graduate them, we move them again, and we risk them having the trauma of another move and moving away from people who really care about them. So I understand it's in the nature of the program. But that doesn't mean I have to like it. Um, so those are the minimum standards set out in statute for treatment foster care. I do not know which circuits will be pilots. They say it will be based on need. And I know there's been a lot of problems in the Tampa Bay area Hillsborough in particular. And I'm not sure, but I'm just not sure how they're going to do the math on that and decide. So I don't know who will be the pilots. Good question, though, Walter. Um, okay, we're still in the big, beautiful child welfare bill. There was this provision. Some of you may have been asked to participate in surveys or research by the Florida Institute of Child Welfare at Florida State University. So this makes it clear that if they offer an incentive for participating, that you are not if you are a public employee, you're not violating standards of conduct and you don't have to report it as a gift. So it's a little break for people to help encourage them to participate in the research of Florida Institute for Child Welfare. Next interesting thing, and this is going to be quite um, tight time frame. There will be a case management workforce work group that has to convene on July 1st and be done with its work on December 1st. They are to bring together people with the expertise in case management and child welfare policy from a variety of different aspects of child welfare, and they've been given a specific set of tasks. There have been talk at various points about the fact that Chapter 39 needs a whole review, rewrite, cleaning up, putting together. I'm not sure that this task force is exactly that. It's really focused on the role of case management. Through the years, every time something really bad happens, case ends up in the news, we add tasks and requirements for case management. The rules, the law changes, the rules and operating procedure changes, and there's a lot on the plates of case managers. Can they actually do it all? Is it possible? Are they trained and supported to do it all? Can there be clarity and revisions that make it more workable? I think these are kind of the overarching goals for this work group and the recommendations that they will end up making to DCF. So it'll be interesting to see. I don't know who has been tagged to get started on that, but again, the bill hasn't been signed by the governor, so hopefully that will happen soon and they can get it cranked up and going. So that's the last piece of this big, beautiful child welfare bill. Any questions about that before I move on to the next bill? Okay, I'm going to keep going and you're always welcome to go backwards. So the next bill relates to the transfer of foster home licenses. This was a very clear, simple, short bill, and some legislators I'm sure, have been approached by foster parents who move, licensed in one part of the state, moved to another part of the state, and had to start from scratch to get their license, their foster parent license to be active in their new home. So they just wanted a simple, straightforward, once you have it, if you move, you get it transferred. That didn't work out so well. So they did get a revision to require DCF to adopt rules to streamline licensure for people who move in the state. Um, and the bullets here tell you what that streamlining is supposed to do. The reason that they weren't able to just get the exact, transfer your license is good anywhere, that would jeopardize the federal Title 4E funding. So each location that a family lives in has to be individually studied. So there is a strong desire on the part of the legislature to make it easier for those moves to take place, but DCF is going to have to do that by rule and how it effectuates those review of people who move. So that bill goes into effect on October 1st, and it has been signed by the governor. The next one relates to what I'm going to call free range children. And the bill itself is called Harming or Neglecting Children, and it addresses independent, unsupervised activities. If it is signed, it will go into effect on July 1st. It amends both the Chapter 39 definition of harm and neglect and the criminal statute 82703 definition of harm or neglect. This is brought by an organization called Let Grow. Their website is letgrow.com, and their principles are that children deserve reasonable independence and parents need freedom to make decisions. And so they don't want to criminalize parenting decisions, and that is the purpose of this bill. They've done it successfully in some other states, and it's pretty good because this was their first time around, and usually a new bill can take a couple of years before it goes through. So it's targeted on letting kids travel to and from school or other close locations either by walking or on their bicycle, allowing them to play outdoors without a parent supervising, or allowing them to stay home or another place for a reasonable period of time. The standard for determining whether that's okay is unless the parent conduct is so reckless to endanger the health or safety of the child. And the criminal standard is unless allowing the activities is a willful and wanton conduct that endangers the health or safety of the child. So, and this was in the news recently. I just saw about parents in North Carolina who were um, uh, charged because the mom let their children walk home from the grocery store and one of the children was hit by a car. Um, you know, so it's that balance of when is it okay? It's not neglectful if you make intentional decisions to allow your children to have freedom. So again, this bill has not gone through. It's not been signed yet, but I do see some questions on previous bills. So treatment foster care is different than therapeutic foster homes. It is a specific program. So in a way they are similar, but yeah, I think it's intended to be have a specific organization around it. Um, and I guess actually I can't answer the question. I don't know if it's going to end up being different or the same in the expansion of existing therapeutic foster homes. It's a good question that I can't answer. Um, so on the recruiting, the pay discrepancies between foster parents and group homes. So there's not a um, there's not a specific look at the discrepancy between what foster parents are compensated and what group homes get for children. There was a bill that would have required DCF to um, specify in statute that range. I believe they've adopted a matrix for how much of an enhanced foster parent payment they can pay um, based on the child's needs. That language did not make it into a bill that passed. So, um, who determines sufficient maturity? The parent determines sufficient maturity, and if you know, if someone if a child ends up being injured, I think then it would move into the prosecutor realm to determine whether the parent exercised appropriate judgment. Um, does 1286 affect normalcy for foster children? Not that I'm aware of. If you maybe have a more specific question that it's directed at, but as far as I know, it does not. Um, yeah, that shouldn't. DCF or Leo. Yes. So, um, it's DCF or Leo. It is subjective, but what will happen if the bill is signed is the parents want to have something to rely on to support their decision that that they are not neglecting their children because they were relying on the law permitting them to do these reasonable things. How that will play out, I don't know. It's going to be interesting to see. Um, all right. So I at this point I'm going to turn the discussion over to Jury Seldine, the Executive Director of Florida's Children First. Hang on, I see one more question. Regarding 7012, did anyone suggest that the workforce group report to Citizens Review Board? As far as I know, Citizens Review Board was not part of that discussion, but I did not follow it closely, so I just know what the bill ended up being. Jory, I'm gonna turn it over to you.
Hi, everyone. I'm happy to be here today. My name is Geori, and I'm the Executive Director of Florida's Children First. As Robin briefly mentioned, we have an affiliate organization that is part of Florida's Children First called Florida Youth Shine. And Florida Youth Shine is a statewide, peer-driven, youth-led advocacy organization with over 15 chapters around the state and over 250 members from the ages of 13 to 26 who are from foster care, experience foster care, or also experiencing homelessness. They receive mentorship and leadership programmings. They get support from their peers, and it's just a really amazing program. If you've never heard about it, I encourage you to check us out on our website. And if you have young people, we always want new members, and it's a really rewarding experience for them. And what they do with their advocacy efforts, they do a lot of activities, but each year they participate in a youth action cycle where they host listening sessions, and they developed a youth action campaign with their four main topics that they care about changing most and improving most in the foster care system. They then vote on that, and that becomes their legislative item for the year. And I am so excited to share with you that their legislative item from this past year, which was addressing barriers for youth experiencing homelessness or just in housing in general, passed unanimously in session with the first year that they worked on this bill. So we're really excited about that and all of the potential that it has to really help address this really important need with the housing crisis, especially those people that have experienced foster care or homelessness before. So one of the biggest barriers, obviously the lack of affordable housing with supportive services, is one of the biggest barriers that the young people identified. And they also found that existing housing programs that we have in this state are not being utilized around this state. OPAGA identified a lack of safe and affordable housing as one of those key barriers upon college completion. Next slide. So what does this bill do? So one of the things that this bill does is colleges and universities must create plans to prioritize former foster youth and homeless youth in housing placements. Making sure that they are a priority. This applies to residence halls and dormitories, and it requires UCF's Office of Continuing Care to determine whether those students were formerly in foster care. Next slide. It says that the schools with existing priority systems must give first priority to former foster youth and those homeless students. It also precludes schools from requiring a co-signer for housing if the student is funded under one of the independent living services. It also requires UCF and CBC lead agencies and housing authorities to take required actions to access the foster youth to independence vouchers and other federal housing programs. So as I mentioned, what we were finding was that there were housing programs available, such as the FYI vouchers, which are stipends that are provided to young people. But however, there was only 11 counties that were using them. So what we did was we said that those CBCs and those lead agencies need to partner with those housing authorities to make sure that they're available throughout the county. It shouldn't matter where you're going to school or what county you live in if you have access to this really great program and other federal housing programs. It also requires DCF, CBC lead agencies, and subcontractors to document actions that are taken for young people to acquire a lease. So oftentimes our young people were having to find co-signers and so forth. This does require that there is some facilitation and help for young people to be able to get into a lease. And it also requires an OPAGA study to study the barriers to obtaining housing for youth who are formerly in care or homelessness to see how those efforts will be further informed. And this bill does go into effect technically. It's effective on July 1st, and it awaits the governor's signature. It has not been sent to him yet.
Thanks, Jory. Are there any questions about the young adult housing support bill? And we'll keep an eye on the chat for that too. All right, then let's go to the next bill on developmental disabilities. Senate Bill 112, this has been signed by the governor, goes into effect on July 1st. It really is comprehensive look primarily directed at children with autism. So the first section extends an existing grant program where the Department of Health will help fund nonprofits to do a variety of screenings, and it will enable them to do no-cost screenings to include autism. That tends to be at the front end a difficulty that families have in establishing the diagnosis. So there's no guarantee of funds, but they can now spend this existing grant money to do autism screening. Then it creates a new Center for Autism and Neurodevelopment at the University of Florida. So you'll see we've noted in orange where a new statute has been created. And the idea is they've actually piled a bunch of different responsibilities on this new center to collaborate, coordinate information, to issue this micro credential for showing that people have had specialized training in autism. That's for teachers and child care staff. There is a new statute creating startup funding for charter schools directed at children with autism, and this UF Center has a role in overseeing that, as do they have a role in summer programs for children with autism spectrum disorder. So funding to start those services for kids in the community. It also, this legislation directs Florida to, to seek the extended early steps enrollment. So if you're not real familiar with this part of the law, the Individuals with Disabilities Education Act, IDEA, Part B of the IDEA serves children who are ages 3 to 21. Part C is called Early Steps, and it is intended for children birth to age 3 who have or are at risk of developmental delays or disabilities. So Florida's been doing early steps. Hopefully you've had kids who have been evaluated, and if they need services, get into services when they're young, because they can be highly effective the earlier we can get kids into services. This allows the state to ask the federal government for the extended option of early steps. It is the choice of the family whether the child ends early steps at age 3 and moves into school-based Part B programs when they turn 3, or the family can keep those early steps services until the beginning of the school year after the child turns 4. This will be an option for the family. They can't get both services under early steps and school age, but will allow the families to have a choice for what type of services they want to receive for their children. The law also offers continuing education to teachers to improve their education on developmental disabilities, and adds training and support with regard to autism into clinical educator training. So this bill kind of zipped through and was signed pretty early by the governor. The next one is the Spectrum Alert Bill that went through, and it requires the Florida Department of Law Enforcement to create a spectrum alert. And, the idea is that the earlier we can find and locate children with developmental disabilities who have wandered away or absconded, the better outcomes for those kids. And it's to give crisis intervention and training to law enforcement on de-escalating and, getting those early alerts to find the children. I do not believe that I'm looking at the question. I do not think that they are taking funds away from the CARDS, the Center for Autism and Related Disorders. I think it's a new source of funding, and the anticipation is that the new UF center will, part of what they do will be coordinate with the different cards around the state. So it's intended to be an addition, not a subtraction from existing programs. But that's a good question. Okay. Children's medical services. So I almost tried to make a graph for you all, but I just not good with the Venn diagrams and the process graph. So bear with me as I try to walk you through what's changed with regard to this. So this is Senate Bill 1490. Okay, I'm going to pause because I hear there are questions in the Q&A. Let me pull those up if I can.
Yeah, I can read them out loud. The first
Sure.
one is, are they pulling funding from UCS Center for Autism and Related Disabilities to create the UF Center?
Right, I answered that, and as far as I know, they are not.
Okay, the next one is, does Early Steps include caregivers of children in foster care?
Absolutely. So if you have a child in care who you think is eligible to be screened, you absolutely can get them into early steps, preferably if their parents' rights haven't been terminated, that you would do that with the parents. But certainly, folks in the child welfare system, caseworker can make the referral for the early step screening, and the services are provided in the context of the home. So if the child who's eligible lives with you, then the services should be in the home.
And the next question is, for the extended early steps, do the school sites then need to migrate the Plan A into the school-based IEP? Until now, Plan B migrated the plan to an IEP.
I do not know the answer to that question. It might be in the statute, and I just didn't understand it well enough to share that with you. But I'm not sure what they definitely talk about the transition. I'm just not sure how that's supposed to occur. Sorry, I can't be more specific on the answer on that.
Thanks, Robin. No pending questions for now. Thank
Okay,
you.
thanks. Okay, so Children's Medical Services Bill 14, Senate Bill 1490 is effective when it was signed. So that was 5/27/25. So Children's Medical Services, and this can get really complicated. So Children's Medical Services is a division under the Department of Health. It provides many things. Um, it, um, Things like the child abuse death review team, child protection teams, early steps, medical foster care, newborn screening, information center. Those are under the Children's Medical Services Division under the Department of Health. Before Florida went to managed care for Medicaid, Children's Medical Services was the place that served on a fee for service basis children on Medicaid who had special health care needs. So it was just part of this Department of Health, and lots of families with children who had special health care needs really thought they were being served very well under Children's Medical Services. When Florida went to Medicaid managed care, Children's Medical Services, what they had been doing as a fee for service program, became a managed care plan. And caregivers could enroll their children. The way managed care works is at the option. So if the child was in the child welfare system, they could enroll the child in the child welfare specialty plan that's offered by Sunshine. They could enroll the child, if they were eligible, in the CMS managed care plan or in any of the other plans that served where they were. The managed care plan, so it was kind of under Department of Health, with, I think, assistance in managing from ACA. This is my 30,000 foot view. I'm not in it on the daily basis, but I kind of get the sense that CMS was really good at providing medical services, wasn't necessarily doing a great job running a managed care plan, right? That's not what they're about. They're about doctors and services. So the running of the healthcare plan was not going well, and it has now been moved from the Department of Health to ACA effective July 1st. So, and if you have pending cases, the statute is very clear that the party will just be substituted. You don't lose your case because it's no longer under Department of Health. Judicial and administrative cases will keep moving forward. So the Department of Health will keep the responsibility for determining clinical eligibility and as to whether the child has special health care needs, and they will consult with ACA on the services for children, but the management of the plan, the managed care plan, now will come under ACA. So ACA is supposed to develop these measurements and contract with an independent evaluator to determine how it's doing on these key things. So if you are working with a child who receives Medicaid and has special health care needs, I'm going to go back to the previous slide. At the bottom, that's kind of the definition of special health care needs. So chronic, serious physical, developmental, behavioral, emotional conditions that require healthcare and related services of a type or amount beyond what's generally required. That's what special healthcare needs are. So management is moving over to ACA, and Department of Health will continue to have a role. Let's see a question. Child protection teams remain under Department of Health. The only thing that is moving from Department of Health to ACA is the managed care plan for providing Medicaid services to children. The rest of the list of things that Department of Health does under Children's Medical Services will remain under Children's Medical Services. Good question, Andrew. So there were some additional tidy up things in the bill. I just made a list here for if this is something of interest for you to go back in and to look into more depth. Now, the other thing that's a pertinent issue in this bill relates to the children who receive private duty nursing. And this has been a concern, for families who are trying to keep their children out of nursing homes to have sufficient nursing care and assistance in their home. And to look at offering that tiered level of services to avoid the institutional care. So the idea is to bring in the stakeholders to develop the plan. There have been several different efforts to improve compensation for family members and to try to keep children at home. So this part is like a look at what should be included in this waiver plan. And then I have a question. ACA, good question, Maritza. ACA is the Agency for Healthcare Administration. And federal law requires each state to have one Medicaid agency. In Florida, ACA is the Agency for Healthcare Administration, is that Medicaid entity. And then you say, okay, one entity, but actually DCF does the eligibility aspect of Medicaid. So managing Medicaid comes under ACA. And I am very excited that I think August 11th or 12th, we are going to be hosting a training with Florida Legal Services on Medicaid, especially Medicaid for kids and for young people who are transitioning to adulthood. So we can get into a lot more detail about the offer of Medicaid services under state and federal law at that time. All right, now I'm going to introduce you to my colleague Janine Rice, who's going to talk to you about this big, exciting Sins Fins bill. Janine.
Good afternoon, everybody. My name is Janine Rice. I am a children's rights attorney at Florida Children's First since April of this year. Previously, my my relevant experience is that I was once a crossover prosecutor, which means that I prosecuted children who were in dependency court and committed a delinquent act. And I also represented children with educational needs. And part of this, the delinquency part has been pulled off, if you will, of children in need of services, and the education part has been more strengthened more. And you'll see what I mean by that as we proceed forward. This bill is 118 pages, so it's very comprehensive. Curiously enough, if you look at the Florida Rules of Juvenile Procedure, there are no rules of procedure for children in need of services petitions. There is only about a page and a half related to truancy petitions. And this legislation is going to broaden that, and it requires that there's going to be some express rules of procedure, but the legislature did a pretty good job of laying out what those procedures are in this new legislation. So if we could go to the next slide. So it has not been sent to the governor, but it is, if it is sent to the governor and he signs it, it would become effective July 1st. And there's a lot of time and energy spent in this legislation up front on the legislative intent and purpose. So there's no hidden question as to why the legislature undertook this pretty significant revision of the children in need of services, the SINs part of it, and FINS, which stands for Family in Need of Services. The Senate bill, as you can see there, is 1344. And when you look at the whole bill, you can just tell right away that the tone is different. Definitely you see that in the definitions, but there's a lot of change from sanctions and punitive approach to prevention and intervention. And there's this escalation of efforts that must take place before you even get into the courtroom. And then once you're in the courtroom, there's again an effort at exhausting services. The past law had referred to DCF having a role and commitments and dependency. All of that is taken out. This is a DJJ primary statute with a small role for DCF, and we'll get to that later. So placement in shelter care, which is the only means of, if you will, confining a child, is done as a last resort. And for children who are in the early truancy intervention, it can only be done for contempt. Next slide, please. So there's a whole section that lays out in excruciating detail the steps on how to get an attorney appointed. For the indigent child and the indigent parents, it's not all that extensive. It's what you would expect. But there are non-indigent parents who will show up and say, I'm not going to deal with this child anymore. They're ungovernable. It's not my problem. And I refuse to hire an attorney to protect my child's interests. So for that, there is a scheme, if you will, of the steps that the court has to take in order to get to the point where the court appoints an attorney for the child. No, it's For children, when a petition has been filed alleging that the child is in need of supervision, or if the child is subject to contempt proceedings under the early intervention petition. So there's two different petitions that come under SB 1344. One is the early intervention petition, which enables the superintendent of schools or his designee to file after a series of attempts to do other things has been exhausted, or if the child fits the definition of a child in need of supervision, it's filed that way. So, and I'm not being very clear here, if you've exhausted everything and the court finds in the early truancy intervention proceedings that everything's been exhausted, the court has to refer that child over to a child in need of supervision proceedings. But then there's this whole definition of what is a child in need of supervision. So there's kind of two different types of proceedings under this statute. One is, if you want to think about it as a pre-SINS proceeding, which is the early truancy intervention proceeding, and that's only for children with compulsory school attendance problems. And then the child in need of supervision proceedings are when those proceedings fail, plus children who are runaway and ungovernable. But here, let's just talk about the right to counsel and due process. It's for every stage of the proceeding for a petition for a child in need of supervision and for contempt proceedings under the Early Truancy Act, under the Early Truancy Intervention proceedings. So let's say you have one of these stubborn non-indigent parents. How does the court get to the point of being able to appoint an attorney for the child? And there is, if you're not aware, there is a registry, there's a wheel, using the old school terms, but there's a registry for attorneys to get paid through the JAC for these types of proceedings. And because of this statutory scheme, there's definitely a very clear process on how you get there. So essentially, the parents have to be ordered to do it, hire the private account. So first they come in there and say, I don't want to. No, you have to. Go out and get one and bring one back. And they don't do it. Then I'm just going to, because it's so extensive, I'm going to read a little bit here. Sorry. The court appoints counsel until counsel is provided by the parents. But that's just for this initial appearance. And the court may not appoint counsel for an indigent child with non-indigent, and when I say parents, it's parents, legal guardian, or physical custodian. If the person who's responsible for the child or has the child under their physical care, they have to be ordered to obtain private counsel. And if ordered to obtain the private counsel, but they willfully fail to do so, then they have to be punished with civil contempt proceedings. So they willfully refused a court order, then they have to be punished by civil contempt proceedings. And once that's done, then the child can have court-appointed counsel and treated as if the parents are indigent. And then the non-indigent parents have to make a good faith effort to participate in remedial services. And if that's the case and the child remains truant, runaway, or ungovernable, then the court may appoint counsel. So one is, mandatory and the other one is permissive. The compensation remains the same. So it's not to exceed $1,000 at the trial level and $2,500 at the appellate level. So there's this whole thing that the court has to go through. So there's no detention anymore for children under Section 984, or Chapter 984. Chapter 985 is the juvenile delinquency chapter. And as you probably know, if you don't, Chapter 39 is for children, what we're going to call the dependency system. So you have typically in the juvenile justice system, which involves both the delinquency and the dependency system, you would have a child who's been adjudicated or has a petition pending under Chapter 39, dependency, abuse, abandonment, neglect, or 985, delinquency. 984, as I perceive it after reading the whole thing, is to prevent the children from ending up in one of those two or both of those two options. Yes, 27.511 is expressly referenced in the statute. Thank you for that. I'm going to suggest this cursory overview is definitely not a deep dive into the statute. So just kind of pointing out highlights and hold on. Let me just get through this one slide and then I'll go back to the questions. So there's no DJJ detention anymore. Not if you're a child in need of supervision or you're a child who is participating in the early truancy intervention, your consequence is not going to be going to the kids sometimes refer to as the tent. But you're not going to excuse me. You're not going to the JAC, the Juvenile Assessment Center. You're not going to a detention center. You will be going to a shelter. So you're not going to have any form of detention care like home detention. You're not going to be in secure detention and no jails. So none of these punitive sanctions that are used by the Department of Juvenile Justice under Chapter 985 are permitted to be used for children who are in need of services under Chapter 984. So let me take a pause and take a look at the chat or the Q&A, sorry. If a parent calls, I'm sorry.
Yeah, go ahead.
If a parent calls in on her own child, how will this get into sins and not dependency? So this is, my experience in the past has been that ungovernable parents would just refuse to engage with their ungovernable children. And there is a whole process on how you get a child in need of supervision, and I'll get to that in a bit. I just wanted to get through what I thought were the really big deals, which is this extensive due process and right to be represented by an attorney and the whole rigmarole that you have to go through in order to get that attorney for the child when the parent refuses. And also the fact that there's no detention anymore. It's shelter, and it's not sheltering in a DJJ detention facility. Yes, the way it's written to me is it's meant to be a way of, and it's in the statute actually, to be an intervention prior to dependency. Let's see. Will CPIs be able to access this? Well, the question is, will CPIs, Child Protective Investigators, be able to access this in place of requesting a dependency? If the child is not being abused, abandoned, or neglected, then yes. And if you get into dependency shelter, is there any way to engage in sins? No. So it expressly talks about whether or not if there's been a petition but not an adjudication for dependency, yes. So I think I'm going to get to the answers to a lot of these questions in a bit. No, when I use the term shelter, it's a shelter that's been licensed by DCF, but it's not a dependency shelter. Does any of the legislation address whether the GAL attorneys can interact with children's appointed counsel? No, there's nothing. This is not meant for, this is pre-dependency. So if there's a guardian ad litem attorney, that presumes that you're already in dependency, right? So this is for children who do not already fall into one of the other buckets. Okay. And is there anything in the chat that I'm missing? Oh, hold on. Let me back up a little before I move on. I'm going to the chat now. Let's see. Marcy Silver said that I think under 27.511, the Office of Regional Counselors are supposed to be appointed to proceedings first. I'm assuming whichever needs attorney first, parents or the child. So my focus is was on the child's attorney. It's when you have an early truancy petition, it's permissive. So you're in court, but it's permissive as to whether or not anybody gets but of course, if the court is, let's see, I'm just gonna, I think the better thing to do here is to have you read the statute, the section that specifically relates to the appointment of counsel. If a parent calls in on her own child, how will this get into sins and not dependency? And I'm going to address that in a little bit. How do you get on this wheel? So the registries are just like you would if you're going to represent, we call them special public defenders. They used to be called the wheel. Each circuit has, and you have to qualify based on having experience. But usually I'll talk about my circuit, the 17th circuit. If you signed up to represent children in a dependency, they would just automatically put you into the registry for doing these cases as well.
So I think, Janine, just keeping
yeah.
an eye on the time, and
Yep.
all registries are run through the circuit court, so I answered that in writing.
Oh, okay.
I need you to
Okay.
hop back on
Sure.
what you wanted to convey so that we can wrap up with what didn't pass and
Okay.
keep to our time. So
Sure.
I think you were ready.
Yeah. So people were asking me about how to get a child in need of services. It's when there's no pending petition alleging the child is delinquent. There's no current court-ordered supervision under Chapter 985, the delinquency, or no court-ordered supervision by DCF under Chapter 39. So to the question about what can a CPI do, if there isn't any court-ordered supervision yet, the child hasn't been adjudicated, and there hasn't been a disposition order, then you don't have court-ordered supervision. Who are children in need of services? They've persistently run away. They're ungovernable. And the really important point I wanted to point out about ungovernable is that you have to have capacity. A lot of times in civil proceedings, we just do not address whether or not people have capacity. But in this case, for a child to be ungovernable, they have to have the mental and physical capacity to understand and obey the lawful rules and demands of their adult family members, parent, guardian, custodian. And so I think that's very important if you're going to be defending these children. Next slide. I talked about early truancy intervention already. It's an action taken by a school district superintendent or their designee, and it's to get in early and nip the non-attendance in the bud before it becomes a DJJ problem. And then here's the talk about the shelter. The shelter facility has to be licensed by DCF, and it has to have 24-hour continuous supervision, but it's not physically secure. Next slide. A physically secure shelter, on the other hand, is one that is, as you would imagine, physically secure. It's locked, or it's a locked unit within a facility. It's licensed as a child caring agency by DCF. And it is the last resort. And I'm going to address the last resort at the very end. So, needs assessment. This is just an example of all the information that needs to be collected and gathered. I view it as something very similar if you're in education to the IEP, where you talk to everybody and you want to gather as much information as you possibly can about the child so that you're delivering narrowly tailored services that will specifically address this child's needs. Next slide. Voluntary family services. Again, it's an intervention that's put in place to keep the child from escalating to going to a shelter, to keep the child in place from escalating to a physically secure, or ultimately being referred to DCF for staffing.
Oops.
Truant status offender, there's no longer any delinquency involved. Any sanctions or consequences are not to be delinquency sanctions. It's a civil status. Next slide. So the court has to exhaust, well, once you get to court, the court has to exhaust the alternative sanctions. And if it becomes obvious that the sanctions aren't working, then the court, when it finds a child is willfully not following the court's order with regards to services, can do the following. Contempt has to be preceded by due process. So there must be an order that is served on the child so that the child has notice and the child is represented by counsel. And the maximum sheltering is for 5 days for a first offense and it's permissive, and up to 15 days for any second or subsequent contempt findings, but only if a shelter bed is available. And if a shelter bed's not available, you go on a wait list, and the child that's been on the wait list the longest gets the next bed. And there's very specific things that must be found before you go to the physically secure shelter. So it's, like I said, the shelter of last resort. So after a second or subsequent contempt finding for an early truancy intervention child, the court must refer the child to a case staffing committee with the recommendation that the case staffing committee file a SINS petition. The court can't order them to file, but he or she can certainly recommend that they file the SINS petition. And the case staffing committee in the statute has a whole list of things it must consider and a process it must go through. If you're going, as a judge, if you're going to order a child to a shelter placement, you can't do 5 + 5 + 5 for each time the child doesn't do something you told the child to do. You look at all of at that point, at that hearing, these are all the things that I've said that you didn't do when I told you to do them. And this is on a first offense. I'm going to sanction you with up to 5 days at a shelter, and on a second or subsequent offense, up to 15. But it's not 5 or 15 for every little thing that you didn't do that I told you to do. The voluntary family services includes homelessness in addition to truancy, runaway, and ungovernable behavior. So homelessness is not a reason for a petition for a child in need of services to be filed, but homelessness is part of the family services, part of the things that can be remedied with these voluntary family services. So this is to address that question about what can the CPI do. If there is a pending investigation into an allegation of abuse, abandonment, or neglect, the child may be eligible for those voluntary family services if DCF makes the referral. And there's going to be an interagency agreement between DJJ and DCF to govern this referral process. And it's contingent upon funding. And if DJJ finds out that one of the DCF providers declined a referral, they have to go back and tell DCF that that's what happened and not just let it sit out there. Also, case management is now a specifically identified service. I used to represent adults in felony mental health, and case management was probably the best thing that those folks could have. And I think it's a really great thing that the legislature wrote it into this statute. Okay, so a child is going to get picked up because they're truant. It used to just be that a law enforcement, or it was typical that a law enforcement officer can do it, but a designated school representative can do it now. And where do they take the child? To a designated shelter facility, to a parent, guardian, legal guardian, or custodian. But if they do that, then they must make a full written report. So that's a bureaucratic obstacle. So maybe they're not going to take the child back to the parent because they have to file a report. Who knows? We'll see how this plays out. And then other places where the child can be taken to, if qualified, is hospital, a public receiving facility, addictions facility, and the like. There are times when a child can ask, when they've been picked up, if they can go to shelter. And that can happen, but the shelter after 20 has to notify the parent, guardian, or custodian where the child is, and the proper arrangements can be made as long as the child can go home safely. But after 24 hours of attempts, and this sometimes would happen when a parent would refuse to pick up a child when they're being released from the jack, after 24 hours of attempting to get in touch with the parent or the guardian or the custodian, and with no success, or they determine that the child cannot return home safely under these conditions, then DCF must be contacted. And that's the language in the statute. DCF must be contacted. Next.
And that's it. And Janine, there's a question I think I'm going to ask you to answer in the Q&A, if you can answer it in writing, because I want to just quickly zip through.
Sure.
Thank you very much, Janine. The what failed, and I always like to kind of give a highlight, just a quick overview, because excuse me. Pardon me. Because some things we're going to see again, and you want to know what's on people's minds. So in the child welfare bill, I've highlighted here Patterson's law, which would obtain a second opinion on a medical evaluation to see if a condition might have caused or increased the risk of a misdiagnosis. This bill went really far this session for its first time around, so I can expect that you can expect to see it again next year. the one underneath it on CBC lead agency and subcontractor liability. This is a limitation of damages. It's a recurring kind of cycle of concern with regard to access to the insurance to cover claims for children who are injured in care. This bill ended up being workshopped this year, so it wasn't heard as in a hearing for moving it forward, but it's clearly an issue that's of concern and will come back again next year. The investigation of military families, a bill that, and I mentioned to you, requiring DCF to set this fee schedule for room and board in a rule. That was in a DCF bill that didn't make it through. It also had language regarding unaccompanied alien children, so wouldn't be surprised to see that back up again. The siblings and out of home care bill was Florida's Children First bill that would give siblings standing to file motions for visitation in open cases when they have siblings that are still in care. And I anticipate that that will come back up. There were a bill for promoting post-adoption communication and contracts for adoptions out of the child welfare system, and would definitely expect to see that again. Prosecuting children as adults, we see that very frequently, and that law will continue to be tweaked until people are satisfied with it. And then the online materials, online access to harmful materials, the use of social media, those kinds of things. We are not done with that. And if you want to learn more about that, then I hope you will be, if you are at the Florida Bar annual meeting next week in Boca, the public interest law section is doing a presidential showcase that's going to address that online access for kids. And it will be of interest to everyone who has kids or works with kids. So it kind of jammed through. This is our contact information. We are always happy to answer questions, help you sort out what you're trying to figure out. And I will take a quick look to see. Jorge is giving you the information about where the materials, these slides will be uploaded, and hopefully we've addressed all of the questions. I thank you all for listening in and asking your questions on the Q&A, and you know where to find us later. If you have follow-up questions, keep your eye on the legislature. Hopefully in the next couple weeks, everything will be signed and go into effect. So thank you, everybody. Jorge, back to you.
I'm checking the chat just in case. I see a lot of thank yous. And yes, thank you again for this amazing presentation and very timely updates. Kind of really enjoy seeing what didn't pass. Sometimes we don't pay attention to those bills that don't pass. So thank you for sharing that with us. As Robin mentioned, I shared multiple links into the chat. I did drop the CLE code, which I'm going to read out loud just in case for anybody that needs the code. It's 2506340N. I will include this code and other information in the email that Zoom will send out automatically. I will also include it in the YouTube description as well. And if any of you need a certificate of attendance, I've already seen a few emails come in. I'll get right to it after we wrap up. Please email me and I'll get those certificates ready for you. So I keep seeing a lot of thank yous, Robin. I don't see I've missed any questions. Let's see, just in case. Taking a second look. Let me take a look at the Q&A. We may have a few questions in the Q&A. Well, thank yous as well. So mark them. And yes, I will be providing the certificate of attendance afterwards. So let's see. Final call.
They would like
Yes,
your
I will drop my email here again.
Yeah.
Staff.legal.org. That's my email just in case. And yes, any final statements, Robin, before we wrap up?
Yep, just email Jorge for the certificate of attendance if that's what you need. Thanks everybody. Like I said, we will be back in August with a training on Medicaid, and we have a few others in the hopper, and we hope to see you at those as well. So thanks everybody.
Right. Thank you, everybody. Bye-bye.
Bye-bye.